The Honourable Clayton Cosgrove.
Mr Chair, I just want to revisit some of the questions I asked the Minister because, with respect, they weren't answered. Fundamentally, what Labor members who have and other colleagues who have taken calls want to know, because we couldn't get it out of officials, thank you, is whether this bill will work. Whether it will work, given the reversal of the primary government proposition. For instance, if we look at page 2 of the commentary, it talks about, given the reversal, the lack of benefits either to business or the patent attorney firms making applications on their behalf. It talks about increased administrative costs to New Zealand businesses. It talks about, in the following bullet point, significant costs. It talks, and then we go to consultation and quantifications of cost, and I quote, "We consider that there was a lack of," this is the committee's report, Minister, "that there was a lack of consultation with patent attorneys and the rest of the industry before the development of the proposal of these enabling provisions. Moreover, we consider that the quantification of the likely cost, that is, the costs of developing and implementing these processes and the compliance costs of the industry and patent applicants, was inadequate." Now, my simple question is, as we posed in the Labor minority report, given that there was no cost-benefit analysis done or demonstrated, unless one accepts that the notion of back of envelope, quote unquote, and best guess, quote unquote, and I'm trying to think of the figure that was given to us, but forgive me, I can't remember, unless you consider that that is appropriate cost-benefit analysis. So my simple questions, and I'm just going to take a short call, is can the Minister give the industry, and by that I mean the innovators, not the patent attorneys, the innovators, not those who charge fees, but the innovators who need intellectual property protection, an assurance that this reversal, one, will work to their benefit? And if the answer to that question is yes, could he demonstrate that either by quantifying a cost-benefit analysis, which I assume his officials now, some weeks that it has been from the Select Committee process, will now have done? Could he quantify that, and could he tell us what the benefit of this reversal will be? Because, as other colleagues have said, we're supporting it. We supported the original proposition. It was reversed. We're supporting this proposition because we want to see this legislation work for the benefit of the innovators. But we remain, and we've made this clear in our minority report, none the wiser with respect, and it's a rather unusual legislative position to be in, where legislators will support, go through a process, support legislation, but still have a major question mark as to whether the rationale that they were presented, such flimsy, such that it was, will actually give effect to the intent of the legislation. So we simply seek assurances around its effectiveness, and if the answer is yes, it will be effective for that innovative part, that innovative industry, those entrepreneurs, then can that be demonstrated? Can some evidence be provided in respect of quantification of costs and benefits? I think that is a reasonable, non-political request to make, and I'm sure all the constituencies in the sector will be gratified for those assurances by the Minister.